Big shout out to Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there. How about that?
We are next taking up the case of people of the state of Michigan versus Travis William Behrens. This is file number 24-3488-FH. Appearances, please.
Thank you, David Denham on behalf of the people.
Robert Champion appearing on behalf of Mr. Behrens, who's appearing by Zoom, Your Honor.
Thank you. Mr. Behrens joins us today via Zoom from the Missaukee County Jail. Mr. Behrens, are you able to see and hear the court, sir?
Yes, sir.
Thank you. We are here today on a initial pretrial conference. Mr. Champion, what are we doing today?
Your Honor, we don't have a final resolution in this matter, but I believe the parties will stipulate to an order with the court's permission that will allow my client to be released from custody and report immediately to treatment once we have a finalized date. He has been accepted, but the facility needs a release date or a confirmation that he could be released for that date so he could enter the program.
Do you have a proposed date? Like, do they take patients in on Mondays, Fridays, Tuesdays? Can you give me an idea?
Because of this being a touchy issue for the treatment facilities, all they will tell me is that he has been accepted.
Okay.
Once I'm able to tell them that he can be released, then they will give me a specific date, which I will put into the order.
Mr. Denham, oh wait, I'm sorry. Is it your case?
It is, Your Honor.
Thank you. Your position?
With respect to that, Your Honor, we would not oppose that, but we would ask that standard terms apply. We would ask for the no contact to continue. With respect to Kaylee Behrens, we would also request that there be a GPS tether and the standard condition as far as when, if the defendant were to leave the facility or when he successfully completes it, that he would be required to report back to the Missaukee County Sheriff's Department.
Yes, sir.
That's correct, Your Honor.
All right. Is it treatment for controlled substances?
It is, Your Honor. Alcohol was the major contributing factor in this case.
Okay. So initially, when I look here at the charges, I see some relatively egregious acts of violence, at least suggested. Again, I make no findings, of course. I know nothing other than what I see on the compelling information. And they appear to be relatively serious. And they obviously initially they don't seem to support substance use disorder, but does he have any hold on, let me take a look at the habitual enhancement. The habitual enhancement doesn't include any drug or alcohol crimes. And I'm really concerned here about the nature of these offenses. Mr. Denham, what can you tell me about the situation here? When I see, I've got an unlawful imprisonment, assault with intent to do great bodily harm, issues regarding phone lines, child abuse, domestic violence. Yes. Well, and it's allegedly occurred all in one day. Is there for instance, there's a domestic violence against the same person for whom there is an assault with intent. Did that happen the same day? Was it the same event? Was there two different events?
Yes, Your Honor. One of the children was in, the victim, first of all, the alleged victim is the defendant's spouse, been together for 7 years, married for 4. The child abuse allegation surrounds the fact that the defendant's wife had one of the infant's child in her hands when this was going on.
Okay,
And she was allegedly prevented from leaving for a period of time. So those are the allegations. We can see that they are, I agree that they are serious. Right?
Yeah. All right.
Your Honor, but I believe the alleged victim, my client's wife, is the one also pushing for this treatment.
Well, I assume there are no contact provisions here as adjournment to probation or bond, I mean?
That's correct, Your Honor.
Yes, Your Honor.
Yeah.
Both with the victim and the address. Your Honor.
At this time, the court is going to deny the motion to modify the bond. And the reason here is that I understand the defendant might have some substance use disorder issue. I would like to know more about the defendant's prior criminal history, but I'm very concerned here for an act of domestic violence. And in my experience, when I see domestic violence cases, when I was a prosecutor, I'd say 95% of the time the victim came to me and begged for me to drop the charges. And that was often because people were being manipulated by it. And if I were to release the defendant to some other facility, I can't monitor his telephone calls. I can't monitor his contact with a victim in this case. And I'm not going to allow it. I'm not going to do that. If he's in the jail, I know the jail is probably monitoring every letter and every phone call to make sure that he's not having any communication with the victim or victims in this case. And that's very, very concerning to the court. So therefore, at this time, the court denies the motion to modify bond. Of course, it can be raised again if there's any further information. Thank you. We are adjourned.